Welcome.
Good morning. 5 years ago, the legislature passed and the governor signed SB 332, which statutorily made it clear that landlords have the authority to prohibit smoking cigarettes or other tobacco in rental units. That new law aligned with the already existing ban on smoking in the workplace, while also recognizing that secondhand tobacco smoke may cause death or serious illness. AB 2300 seeks to extend the same authority for landlords to prohibit medical marijuana smoke. Current law already prohibits a qualified patient from smoking medical marijuana 1,000 feet away from a school or other youth-related centers, on a school bus, while operating a car or boat, and in any place where smoking is already prohibited by law. This bill makes it clear that landlords can also prohibit smoking medical marijuana within rental units to protect tenants. Secondhand smoke, regardless of whether it's smoke from tobacco or marijuana, is especially problematic in multi-unit apartments and condos because the smoke easily travels through the windows, doors, and other ventilation systems. Neighbors living in multi-family housing can be exposed to toxic or unwanted secondhand smoke. It's a nuisance that tenants should not have to live with. By now, we're all aware of the dangerous secondhand tobacco smoke can be to the body, but the awareness for secondhand marijuana smoke is not the same. Just last week, there was a briefing across the street on the dangers of secondhand marijuana smoke. The University of California briefing highlighted a recent study by UC San Francisco research Professor Matthew Springer, who's a professor of cardiology at UCSF. Professor Springer's study states that smoke from marijuana can damage your heart and blood vessels as much as secondhand cigarette smoke. This study highlights another reason why we need to make it clear in law that a landlord has the ability to prohibit medical marijuana smoke. AB 2300 does not infringe upon the Compassionate Use Act, Prop 215. Prop 215 clearly states that it is intended to ensure that seriously ill Californians have the right to obtain and use medical marijuana for medical purposes. But Prop 215 does not specifically mention the right to smoke marijuana. AB 2300 does not prohibit other consumption forms of medical marijuana, such as edibles and oils. Qualified patients will still be able to obtain and use medical marijuana through all other non-smoking ways. Here in support is Shant Apekian of the California Apartment Association, and I respectfully ask for your aye vote.
Thank you. So your witness in support.
Mr. Chair and members, Shant Apekian on behalf of the California Apartment Association. We are in support and sponsors of the bill. As the Assembly member stated, about 5 or 6 years ago, we sponsored a very similar bill that was overwhelmingly passed and signed into law that allowed a landlord, or expressly clarified the landlord's ability to prohibit tobacco smoke. I think the smoking of medicinal marijuana is a major source of conflict between tenants that smoke and their neighboring tenants that don't smoke. In multifamily housing, it's very easy for smoke to travel from one unit to the next, whether it's through windows, shared ventilation systems, or walls. And we hear up and down the state from our members who repeatedly really get caught in the middle between tenants smoking and families next door who claim that they simply don't want their kids exposed or they themselves don't want to be exposed. So we think this bill is a narrow but important fix that will help clarify the law, and we ask for your aye vote.
Was due pass as amended. Your bill is out, Mr. Wood. Thank you.
Thank you very much. Appreciate it.